Hello everyone, welcome to Ezymentors. This is Sanjay Thakur, an educator of Indian Constitution, Polity and Governance. Today, I am here to discuss a very important topic corresponding to General Studies Paper 2 in general and Indian Constitution in particular. The name of the topic is whether fundamental rights are amendable or not. Fundamental rights are exclusively the subject matter of Indian Constitution, though General Studies Paper 2 comprises of different segments starting from Indian Constitution. After Indian Constitution it comes Indian polity, thereafter it comes Indian governance, social justice, and finally international relationship. So across all these 4 to 5 dimensions, the entire GS paper 2 has been configured across a total of 20 units, and out of all those 20 units, there is unit number 1 which is largely dealt with the issues concerning constitutional scheme. More precisely, you can say it makes the mention of Indian Constitution in your syllabus. If you look into the worth of Indian Constitution corresponding to UPSC Civil Services exam preparation, in preliminary examination, it has a greater weightage. For say, if you look into every year Civil Services preliminary exams paper, you will be certainly finding nearly 12 to 16 questions coming from Indian Constitution. I mean Indian Constitution and polity, in more precise term, I will say. So from 12 to 16 questions corresponding to Indian polity and constitution, nearly 8 to 10 questions directly overlap with unit number 1 of General Studies paper 2, which is named as Indian Constitution. Of course, it is also having a required weightage corresponding to written examination, that is mains examination. So for mains examination point of view, you will have nearly one question every year. The weightage of the question may be varied. Sometimes it is asked under the bracket of 10 marks question. Sometimes it is asked under the bracket of 15 marks questions. Because in entire General Studies paper 2, you will have two sets of questions. One set of questions are related with 10 marks questions. They are 10 in number, and each and every question shall have to be written in a maximum word limit of 150 words each. Another 50% questions means remaining 10 questions. They are of 250 words question, and their weightage is basically 15 marks per question. So weightage wise, you may have 10 to 15 marks question every year in Civil Services mains examination from the particular topic of Indian Constitution that has been given in the form of unit number 1 in General Studies paper 2. Okay, so under Indian Constitution, I mean in GS2, under Indian Constitution, I am going to discuss a very conceptual topic with you. The heading of the topic is whether fundamental rights are amendable or not. Whether fundamental rights are amendable or not. Look, fundamental rights are basically referred as the core philosophy of Indian Constitution. Remember, Indian Constitution is the mother of all the laws that are prevailing across Indian polity. And under Indian Constitution, fundamental rights are basically the hallmark of Indian brand of democracy. If you look into the opinion of one British scholar, more precisely you can say one British law expert whose name is Grenville Austin. Grenville Austin was of the opinion that the chapter on fundamental rights given under Part 3 of Indian Constitution is basically the cornerstone of Indian democracy. So, fundamental rights simply show the guarantee of the prevalence of the kind of democracy that is found in India. The kind of democracy that is found in India is prima facie a kind of political democracy. Political democracy is usually represented by a means of political institutions and their modes of functioning. But if fundamental rights be clubbed together with the chapter on DPSPs, that is Directive Principles of State Policy, more precisely you can say, if Part 3 and Part 4 of Indian Constitution are clubbed together, the horizon of democracy in India will be expanded, and it will simply go beyond it being a political democracy to a full-fledged democracy. Okay, so once the two noble provisions of Indian Constitution, namely the fundamental rights and the DPSPs, are clubbed together, the horizon of Indian democracy will be expanded. Our democracy be converted from it being a limited democracy to a substantive democracy. It will be expanded from it being a political democracy to a full-fledged democracy. So democracy will be transmitted from it being a politics into a complete lifestyle. So this is how one can realize the importance of Part 3 and Part 4 of Indian Constitution. Right now, we have been trying to concentrate upon Part 3 of the Constitution, which talks about the provisions concerning the fundamental rights. Remember, basically the heading is whether fundamental rights are amendable or not, but for the time being, I'm just trying to get the topic fundamental rights introduced in front of you. Fundamental rights are basically those sets of rights which are, in the opinion of the forefathers of the Constitution, very much instrumental for observing overall personality development of the individuals in India. See, every kind of right is necessary for an individual's personality development. Every kind of right is contributing towards your personality development in one or other manner. But when it comes to fundamental rights are essentially contributing towards observing the overall personality development in you. For example, be it social development, be it political development, be it intellectual development, be it spiritual development, even it corresponds to plutonic development. Okay, so fundamental rights are basically a kind of complete package of rights under Indian Constitution, which are very much helpful in observing throughout whole personality development and overall personality development and all-round personality development across the individuals. Because of their intensity, because of their utmost importance, the constitution makers have also provided utmost degree of judicial protection towards the fundamental rights. For example, see, if any other kind of right or rights provided to you is being violated, in that situation, you are supposed to refer the law courts, and the law courts will be providing protection against the violation of your respective rights. But if the case is of fundamental rights, our Constitution under Article 32 simply allows you to have a rush towards the Supreme Court of India, to have a direct approach towards the Supreme Court of India. You can knock the door of the Supreme Court of India, and the Supreme Court will be always there to provide protection to your fundamental rights. Article 32 ensures that there shall be the constitutional responsibility of the Supreme Court to provide protection to individuals' fundamental rights. Always remember this point. Okay, so this is basically the introduction regarding fundamental rights. But basically, what we have to discuss today is the given topic. The topic is whether fundamental rights are amendable or not. Remember, like other dynamic constitutions, Indian Constitution can also well be amended. If you look into part 20 of Indian Constitution, there is a particular article named Article 368. Article 368 empowers the Parliament of India to cause amendment towards the provisions that are falling under part 3 of the Indian Constitution in the name of fundamental rights. Okay. So Parliament has the power to amend the fundamental rights. But regarding the Parliament's power to amend the fundamental rights, right since beginning, there was a tussle between the two distinct organs of Indian government, namely the Indian legislature vis-a-vis the Indian judiciary. The Indian legislature means the Parliament of India. The Indian judiciary means to say the Supreme Court of India. And this tussle, this conflict starts from the very beginning after the commencement of the Constitution dated 26th of January 1950. Once the Constitution got commenced and aftermath, the then government of India had decided to formulate and implement so many, policies and schemes regarding how to observe socio-economic justice amongst the masses in India. So in order to ensure socio-economic justice amongst the masses in India, the government of India had decided to, take the reference of certain relevant laws. And that laws are basically related to carry out agrarian reforms. Why? Because those days, India was known to be a country of peasants, a country of farmers. India was, largely an agrarian economy. So India being an agrarian economy, if it could have been tried to ensure socio-economic justice, obviously the government shall be focusing upon how to cause, requisite reforms in the domain of agriculture, husbandry, animal husbandry, and in the domain of land reforms. So in simplest possible term, I can say that the then government of India had decided to, formulate certain land reforms related laws. But the point was, those laws were simply causing conflict with one or more fundamental rights. Remember, under Part 3 of Indian Constitution, there is a provision named as Article 13. If we focus upon the material aspect of Article 13, Article 13 simply makes us know about the fact that how a relationship should be maintained between an ordinary law and a fundamental right. For example, Article 13 says that neither a pre-constitutional law nor a post-constitutional law shall be allowed to show inconsistency with one or more fundamental rights. In case a law is having non-resemblance or inconsistency with one or more fundamental rights, the law shall be declared as unconstitutional up to the extent of such inconsistency. So this is how Article 13, plays a pivotal role in establishing the relationship between a law and a fundamental right. A law and a fundamental right. Okay. So when Government of India was planning to formulate land reforms related laws, it was found that such laws would be in one or other manner violating one or more fundamental rights. More precisely, the fundamental rights given under Articles 14, 19, and those days even Article 31. Though Article 31 got removed from the list of fundamental rights after 44th Constitutional Amendment Act that took place in year 1978. Okay, but those days Article 31 was also used to be one of the fundamental rights in the name of right to property. Right to property. So this was basically a dilemmatic type situation which the government of India was confronting. So after facing all such difficulties, after going through all such anomalies, the government of India was left with no choice but to ask the Parliament of India to go ahead to cause relevant constitutional amendment across Part 3 of the Constitution. And accordingly, first Constitutional Amendment Act was carried out in year 1951. What was the result of the first Constitutional Amendment Act that took place in year 1951? It resulted into the incorporation of Article 31 capital A and Article 31 capital B in Part 3 of the Constitution. So, incorporation of Article 31 capital A and Article 31 capital B, it was basically the result of the first Constitutional Amendment Act, which was carried out by the Parliament of India in year 1951. Okay. So, after getting Article 31 capital A incorporated in Part 3, the provision was made like if a law has been made to carry out agrarian reforms, okay, such law shall be provided with immunity against the fundamental rights given under Articles 14, 19 and 31, though the fundamental right under Article 31 is no more, but those days Article 14, 19 and 31, these three fundamental rights means against these three fundamental rights, an agrarian law means a law seeking to cause reforms across the field of agriculture, animal husbandry, land reforms and all. Such law in due course of its operability shall be allowed to enjoy, immunity against certain fundamental rights like the fundamental rights given under Articles 14, 19 and 31. Okay. Similarly, when it comes to Article 31B, Article 31B makes the provision that if a socio-economic justice related rights or if the socio-economic justice related rights are to be ensured, and in order to ensure socio-economic justice related rights, suppose the state has formulated a law, that law shall be allowed to enjoy immunity against all the fundamental rights. It means that whatever the developments that were made via means of the first Constitutional Amendment Act, which took place in year 1951 in the form of the incorporation of Article 31 capital A and 31 capital B in Part 3 of the Constitution, they were simply, imposing limitations against the fundamental rights. And the point is, Article 13 simply clarifies that no law shall be allowed to remain inconsistent with any of the fundamental rights. But the Parliament, through the means of Constitutional Amendment Act, made the provision of, made the provision that certain laws may show inconsistency with one or more fundamental rights. All such developments took place in year 1951, in the very beginning, just after the commencement of the Constitution. This matter became a much talked about matter those days. And finally, it was challenged before the Supreme Court of India in the form of a very prominent case. The name of that case was Shankari Prasad versus Union of India case. In Shankari Prasad versus Union of India case, the matter was raised like whether the Parliament of India is competent enough to cause amendment across the fundamental rights. Can Parliament of India, through its power of constitutional amendment, make such provision which allows an ordinary law to remain inconsistent with one or more fundamental rights? And even though being inconsistent with fundamental rights, how can such law be allowed to enjoy constitutionality, legal sanctity? So this question has become, a matter of great concern those days, because people were, very much apprehensive of the fact that whether Parliament can, impose limitations upon the fundamental rights or not. Because majority of the people, majority of the scholars, They were having the opinion that fundamental rights under Indian Constitution enjoy transcendental position, superior status. They are the superior, I mean, the much superior provisions of Indian Constitution. How they can be amended? So, for the first time, through the help of a particular case law, namely Shankari Prasad versus Union of India case 1951. Shankari Prasad versus Union of India case 1951. The Supreme Court had clarified the powers to be enjoyed by the Parliament of India. And Supreme Court had stated that the Indian Parliament enjoys two sets of power. The Parliament of India enjoys two sets of power. One is the ordinary legislative power, and the other is the constituent legislative power. Okay. The court had opined that whatever be done by the Parliament of India within the edges of its ordinary legislative power, that would be referred to as an ordinary law. An ordinary law. It means that the Parliament has the power to formulate the ordinary laws. The Parliament has the law-making power. When it comes to constituent legislative, jurisdiction or constituent legislative power of the Parliament, the Supreme Court stated that whatever the Parliament of India commits or whatever the Parliament of India discharges in the name of its responsibilities within the ambit of its constituent legislative power, that shall be referred to as the constitutional law. That shall be referred to as the constitutional law. The constitutional law can also be referred to as, can also be termed as the amendment of Indian Constitution. The amendment of Indian Constitution under Article 368. So, in simplest possible term, you can say that the Supreme Court had clarified across Shankari Prasad versus Union of India case 1951 that the Parliament of India enjoys two sets of power. One is the ordinary legislative power and the other is the constituent legislative power. The result of ordinary legislative power is ordinary law, and the result of constituent legislative power is constitutional amendment under Article 368 or a constitutional law. A constitutional law means Parliament in one hand can formulate an ordinary law, and at the same time, on the other hand, it can also formulate a constitutional law. Remember, constitutional law is called as the supreme law of the land. Ordinary laws shall have to show consistency with the constitutional laws. Okay, so under Indian constitutional scheme, ordinary laws and constitutional laws, they have not been provided with level playing field. They cannot be, put onto same platform. Ordinary laws are basically subordinate to the constitutional laws. The examination of the validity of ordinary laws simply depends upon whether such laws are consistent to the constitutional laws or not. Means constitutional laws are basically the landmark to, examine the validity of the ordinary laws. So whenever the judiciary goes ahead to review an ordinary law, the first and foremost job to be performed by the judiciary is to establish a resemblance or similarity between the ordinary law and the constitutional law. To examine whether an ordinary law is showing consistency with a constitutional law or not. If an ordinary law is having inconsistency with a constitutional law, the ordinary law shall have to be declared unconstitutional up to the extent of such inconsistency. Okay, this is the reason why constitutional laws are treated as the fundamental law of the land, the fundamental law, you know. Okay, so it was became perceptible in this particular case that the parliament has the power to carry out amendment across the fundamental rights, and thereby this confusion got ended, and people were acclimatized of the fact that yes, the Parliament of India has the power to carry out amendment even across the fundamental rights. So whatever the amendments we carried out in year 1951 in the form of the incorporation of Article 31 capital A and 31 capital B in Part 3 of the Constitution, that is not, or that are not exceptions. Parliament can do so. Okay, fine. So whatever the stand shown by the Parliament of India in Shankari Prasad versus Union of India case in year 1951, it was, consolidated till a very landmark case which was, brought into figure in year 1965. The name of that case was Sajjan Singh versus State of Rajasthan case, 1965. Okay, so the Supreme Court had maintained its stand, which was, started in year 1951 and going till 1965. So in 1951, the court was of the opinion that the parliament has two sets of power, ordinary legislative power and constituent legislative power. For the last time in Sajjan Singh versus State of Rajasthan case 2, the court had repeated the same voice and stated that yes, the Parliament of India enjoys two sets of power. The Parliament has the power to carry out amendment across the fundamental rights. But there was an U-turn in year 1967 in Golaknath versus State of Punjab case, 1967. The Supreme Court of India had entirely changed its stand corresponding to the power of the Parliament to amend the Constitution, more precisely to amend the fundamental rights. And here the court had opined that the Parliament of India enjoys only one set of power, and that is the ordinary legislative power. The Parliament of India has not been provided with constituent legislative power within the ambit of Article 368. Why it was so? The court said that when you go on to refer the textual representation of Article 368, you won't find any reference regarding the fact that Article 368 be conferring, the power on the Parliament to amend the Constitution. No. Article 368 simply talks about the procedure to amend the Constitution, and of course, the procedure would be taking place on the floor of the Parliament only. But it does not mean that Article 368 empowers the Parliament to amend the Constitution. No, it simply allows the Parliament to follow the procedures given under Article 368 to amend the Constitution. So Article 368 should be simply taken as a procedural device. Article 368 is not the source of the power of the Parliament to amend the Constitution. Article 368 simply suggests how the Constitution be amended. What should be the procedure to amend the Constitution? Means Article 368 by no way confers any power on the Parliament to amend the Constitution. And this is how The Supreme Court itself twisted the entire matter. The matter corresponding to which the court was of the opinion that yes, Parliament has the power to amend the Constitution apart from legislating the ordinary laws. But this time, the court says that no, Parliament can only formulate the ordinary laws. Parliament has no power to amend the Constitution under Article 368, and thereby the Parliament has no power to amend the fundamental rights. In response to the court's decision corresponding to Golaknath versus State of Punjab case 1967, the Parliament of India had carried out 24th Constitutional Amendment Act in year 1971. And look, through 24th Constitutional Amendment Act 1971, the title of Article 368 got changed. Earlier, the title was like the procedure to amend the Constitution. But after 24th Constitutional Amendment Act, the title was changed into the power of the Parliament to amend the Constitution and the procedure therefore. Listen me again. Earlier, the title of Article 368 was like the procedure to amend the Constitution. But this time means after 24th Constitutional Amendment Act, the title was changed into the power of the Parliament to amend the Constitution and the procedure therefore. Apart from this, one more development was carried out, and that development was the development across Article 13. In Article 13, a separate clause got inserted like Article 13 clause 4. So two broader changes were caused through 24th Constitutional Amendment Act. One was across Article 368 by getting the title of Article 368 changed, and second was incorporation of a new clause under Article 13 in the form of Article 13 clause 4. And Article 13 clause 4 clearly makes the mention of whatever the things have been discussed across the previous clauses in Article 13, they have nothing to give or take with the constitutional amendment under Article 368. So, if you wish to listen me in layman's term, I would simply like to tell you that here the Parliament has made a simple declaration for the Indian judiciary, more precisely the Supreme Court of India. And the declaration was like, dear Supreme Court, you are not supposed to treat the constitutional amendments in the same way you try to treat the ordinary laws. Ordinary laws and constitutional laws are different. Why this development was caused? This development was caused for the simple reason Article 13 clause 2 simply empowers the judiciary to cause judicial review against the ordinary laws. Means if an ordinary law is showing non-conformity or inconsistency with any fundamental right, the judiciary will come forward, get that law reviewed on the ground that whether the law is having consistency with fundamental right or not. If it is having consistency with fundamental right, then there is no problem. But if there is a kind of inconsistency with one or more fundamental rights, the law shall be declared as unconstitutional up to the extent of such inconsistency. Right? But the Parliament wanted to make it clear that the concept of judicial review should not be extended upon the constitutional amendments that took place within the purview of Article 368. Means judicial review shall be made applicable upon the ordinary laws only, not upon the constitutional laws, not upon the constitutional amendments that were made by the Parliament of India under Article 368. After that, after that, the stand of Indian Parliament was challenged before the Supreme Court in a very, very popular case. The name of that case is Keshwanand Bharti versus State of Kerala case, 1973. 1973. In this particular case, the Supreme Court had affirmed, had accepted the changes that were caused by the Parliament of India by means of 24th Constitutional Amendment Act with a slight twist. What was that twist? The court said that, yes, there is no problem, whatever we given under Article 13 Clause 4, that is okay. Means judiciary has the power to review the ordinary laws only. We are not going to, review any constitutional laws which are to be made by you within the ambit of Article 368. That is fine. But remember, the constitutional laws shall be subjected upon the doctrine of basic structure of the Indian Constitution. It means that you have both the sets of power, the power to make ordinary laws, the power to make constitutional laws. The power to make ordinary laws would be limited by the power of judicial review being enjoyed by the judiciary. That is fine. And of course, it is even acceptable to you only. You also means it is acceptable to Parliament too. There is no, confusion in that. Means regarding judicial review, there exists no confusion between legislative and judiciary. But the issue of confusion, don't you think it was related with constitutional amendment? Parliament wanted that the judiciary should not be reviewing the constitutional amendments made by the Parliament. But judiciary was also keen of, imposing limitations upon the power of the Parliament to amend the Constitution under Article 368. Why? Because it is the sole responsibility of Indian judiciary to provide protection to Indian Constitution. Judiciary, more precisely, its chief representative, that is the Supreme Court. The Supreme Court has been, provided with the responsibility to provide a guard to the Constitution, to provide a protection to the Constitution. So judiciary cannot turn down its face. So in Keshwanand Bharti versus State of Kerala case, the Supreme Court had clearly stated that the Parliament has the power to amend the Constitution under Article 368. Yes, we accept it. Forget the judgment given under Golaknath versus State of Punjab case 1967. From now onwards, we are accepting the fact that you means the Parliament of India, have the power to make the ordinary laws as well as to make the constitutional laws in the form of constitutional amendment under Article 368. But in due course of carrying out constitutional amendment, you need to take care of the doctrine of basic structure of the Constitution. So you can amend any provision of Indian Constitution, including the fundamental rights, provided the basic structure shall not be altered. The basic structure must be taken care of. It was basically a shocking decision. A shocking development, not decision, I'm sorry. It was basically a shocking, something like, very tedious for the Indian Parliament. The Parliament tried to retaliate the court's decision in the form of 42nd Constitutional Amendment Act 1976. And through 42nd Constitutional Amendment Act 1976, the Parliament had once again amended Article 368. And by amending Article 368, two new clauses got inserted into it. One was Article 368 Clause 4, and the other was Article 368 Clause 5. Article 368 Clause 4 and Article 368 Clause 5. Under Article 368 Clause 4, the Parliament had clearly written that whatever the constitutional amendments be made by the Parliament of India cannot be challenged before any court of law. And under Article 368 Clause 5, it was written like the Parliament of India enjoys an unlimited power to amend the Constitution. Don't you think it was something like crossing the boundary? Obviously, the Supreme Court, through Minerva Mills versus Union of India case 1980, got these two, newly developments declared as unconstitutional. The Supreme Court stated that whatever the developments had been made across Article 368 via means of 42nd Constitutional Amendment Act, it simply shows that the Parliament was trying to, snatch the power of judicial review away from the judiciary. And it is something which is going against the line of the doctrine of basic structure of the Constitution. And thereby, these newly made developments are unconstitutional. Unconstitutional. Why? Because they are violating the doctrine of basic structure of the Constitution. So Parliament can cause any kind of changes across the Constitution, but in due course of carrying out any kind of changes across the Constitution, the Parliament has to take care of the doctrine of basic structure. And this is how it becomes clear that the Parliament has the power to amend any provision of the Constitution, including the fundamental rights, provided the doctrine of basic structure, provided the basic structure of the Constitution shall not be altered. Listen me again. The topic was whether fundamental rights are amendable or not. So now, after going through all such discussion, we can easily reach upon a conclusion that yes, the Parliament can amend the fundamental rights like any other provision of the Constitution. But the point is, in due course of carrying out constitutional amendment across the fundamental rights, the Parliament needs to take care of the basic structure of the Constitution. Means, in the name of amending the fundamental rights, Parliament cannot alter the basic structure of the Constitution. In some other sessions, I will be discussing about the doctrine of basic structure of Indian Constitution separately. But for this particular session, I am going to, terminate the lecture. Hope you would have understood the entire discussion. I am also hoping that this lecture will be proved beneficial for you. At last, I would like to convey one message to you regarding the, new launch of a separate foundation base for NCERTs. So Ezymentors is going to, start an NCERT foundation base for all those aspirants who are willing to, ace their preparation regarding civil services examination. Remember, NCERTs are group of such textbooks which are highly beneficial in, preparing the strong foundation. A strong foundation for what? a strong foundation for civil services exam preparation. If you look into the entire syllabi of all the general studies papers, starting from general studies paper 1 to paper 4, NCERT's textbooks are going to be highly beneficial. So every student is supposed to start UPSC CSE foundation preparation after going through the important NCERT textbooks. Ezymentors is launching a fresh batch for those students who are willing to prepare civil services examination. Before getting into the preparation of civil services examination, they have been provided with a great opportunity to join this batch, the batch which is solely dedicated towards NCERT preparation. So I am inviting all of you to get yourself enrolled in that batch. That's all for today. Stay tuned. Thank you so much.